Good afternoon. The question that I'd like to address to you this afternoon concerns the Accessible Canada Act, which Parliament unanimously passed in June of this year, 2019. I want to talk to you about what we, from the disability community perspective, we're trying to accomplish with this law, what we wanted to get in the law, what we're up against, what we asked for, what we got, and now what else we're seeking in a new bill to strengthen it. This is a sequel to a lecture I gave in January 2018, where I outlined what we were looking for in this legislation. Let me just briefly summarize that lecture. Any regulatory law is trying to solve a social problem. The social problem that this one addresses is as simple as it is enormous. We live in a country that is full of serious barriers that impede people with a physical, mental, sensory, communication, mental health, intellectual, or other disability from fully participating. We live in a society that's designed and operated too often as if we're not there. All over 6 million of us who now have a disability in Canada. I've been involved in campaigning for accessibility legislation at the provincial level to tackle this. If you want to learn more about it, check out www.aodaalliance.org or follow at AODA Alliance on Twitter. But provincial legislation can only tackle some of the barriers we face. Many of them, since many of them fall within provincial jurisdiction, but there are a significant number that are within the purview of the federal government under our Constitution. And so for some years, people with disabilities have wanted a national accessibility law passed. In 2015, in the election, a number of us asked the federal parties to promise this kind of legislation. We got some promises, including from the Liberal Party that won the election. They committed to develop a law, and they set about consulting on developing it. What did we want? Well, we wanted legislation to implement the rights to inclusion and accessibility that people with disabilities enjoy under the Canadian Charter of Rights and Freedoms, and in the federal sphere under the Canadian Human Rights Act. The right to equality and access to goods, services, and facilities and employment. And we wanted it to be achieved without us having to fight those barriers one at a time. This was the model that we used for advocating for the Accessibility for Ontarians with Disabilities Act at the provincial level, which we won in 2005. Now we're taking on the federal sphere. The federal government can regulate such things as air travel, banking, radio, television, cell phones, and landline phones, and other kinds of telecommunication, and of course, federally regulated services and federally regulated companies. From our experience at the provincial level in Ontario, and later from what we heard when legislation was passed in Manitoba in 2013 and in Nova Scotia in 2017, we saw a few key ingredients. We want the law to have the goal of an accessible or barrier-free society. Like Ontario, we wanted to have a deadline for achieving that goal. Ontario in 2005 set the deadline 20 years out, 2025. At its core, we want the law to require the government to create a series of regulations called accessibility standards that are enforceable and that will detail specifically what organizations have to do in one sector of the economy or other to become accessible. What they got to do, when they got to do it by. Because by specific rules, we can get more action. By specific rules, it's easier to enforce. We wanted the law to require effective enforcement, public enforcement, And we also wanted the law to use other levers of federal power beyond making and enforcing regulations in order, to achieve this goal. And the most powerful level of public power that we've identified is public money. The federal government, like its provincial counterparts, spends billions every year. It spends it on building infrastructure or giving money to others, like provincial governments or hospitals or municipalities, to build their own infrastructure, hospitals, university buildings, subway stations, and so on. We want accessibility strings tied to those. If you want the federal money, you got to play by the federal rules. That was our theory. Moreover, the federal government gives money out for business loans or business development. Attach strings to say, if you want that money, you got to play by our accessibility rules. Similarly, the federal government spends billions purchasing goods and services for its own operations. We'd like the federal government to have a policy enforced by law that if it's going to buy accessible, because that'll create pressure on the private sector to produce accessible products that'll be for sale or rent, not only to the government, but to everybody. So that was the model. So what happened? Let's pick up where the last lecture left off. When the federal government was elected in 2015, a minister was appointed to lead the development of this legislation. It started out a minister named Carla Qualtrough. Later, it was shuffled a couple times, and when the bill was eventually before the House, it was Carla Qualtrough again. She was a key player in this discussion. And she, during her first round, launched a major year-long public consultation. I want to observe two things about it. The first is, helpfully, at the start of that consultation, the federal government released a discussion guide to help people get a sense of what they wanted to hear about. And that's good. But there was something in that discussion guide that was deeply, deeply troubling. And it, frankly, dogged us throughout the next 3 years after it was released in 2016. It basically announced, in effect, the government appears to have pre-decided before it embarked on its consultation that however it designed this law, its enforcement in the area of federally regulated transportation, like air travel, was going to be done by the Canadian Transportation Agency. And in the area of federally regulated radio, TV, and telecommunication services, it would be overseen and implemented by the CRTC, the Canadian Radio, Television, and Telecommunication Commission. Now, you might at first think, hey, that makes sense. We weren't happy about that. We were deeply troubled because these two agencies have a track record on enforceability or on accessibility. They've had a mandate for some years, and their track record, respectfully, is lousy. And we didn't want to go back to the same agencies that had done a poor job in some vain hope that they were going to do a better job now. We're concerned that their relationship with the industries they regulate is too cozy, and that their own expertise in accessibility, frankly, is demonstrably lacking. The government announced this. Before it consulted, we took issue with it throughout the process. You'll hear more as I speak. The other thing that happened during this, that was significant during this consultation, is the federal government did something that I had not seen the Ontario government do, which is they came up with a bunch of money to give to disability organizations to help them gather input and give their input into what the law would need. Now, that initially sounds like a great idea. It did, however, have consequences you're going to hear about that were unpredictable at that time and became a bit challenging at times. I'm not saying government money is always bad, but the way this played out was a matter of concern. After the government consulted, we reached June 20th of 2018. This was a very important day. At the end of the third year of the government's mandate, the very last day, the last hour of the sitting of Parliament before it rose for the summer, the applicable minister, at this point it was one of the other people who had been shuffled in for a time, introduced the Accessible Canada Act, Bill C-81, for first reading. Our reaction at the time was mixed. On the one hand, we applauded the government for introducing a bill. And we said the bill included some useful ingredients. I'll describe them in a moment. But we also said that as written, it needed substantial improvement to achieve its commendable goals. Now, I'll take you through those, but I just want to explain, as in a courtroom, there's always strategy when you're doing community organizing and advocacy. And in this case, even though there were some really troubling things in this bill, we decided at the outset, speaking for the coalition I lead, the Accessibility for Ontarians with Disabilities Act Alliance, we decided to begin with an overall message of congratulations for bringing a bill forward and opening the discussion. Because if we slammed it too hard right at the outset, there was the risk that the government might decide, if that message carried through, that it wasn't worth bringing the bill back for second reading. We wanted the bill to come back for second reading and to get into committee so we and others could push for amendments to strengthen it. The media love to leap on criticisms, so if it was a negative response on the first day, that would have gotten potentially some coverage, it might have, but on the other hand, it could have actually worked to our disadvantage. That's not to say we withheld criticism, and later, as you'll hear, we totally were ready to come forward with it. But at the outset, it was a matter of timing. So, what was good in the bill? Well, there were several things. First, the bill by its name was called an Act to Achieve a Barrier-Free Canada. And that was commendable. That was really important. It was setting the goal in terms that was had a lot of potential for us. Moreover, the bill had at its core a power for the federal government to create and enforce accessibility standards as regulations. This is what we were looking for. As well, drawing on ideas that we had pitched and others as well, because there were many voices of the disability community being heard, the government included in it the creation of a new federal organization, the Canadian Accessibility Standards Development Organization. Here's a new word for you, CASDO, C-A-S-D-O. And it was to include people with different disability perspectives or other expertise, and it was intended to be able to give the government recommendations of what standards need to be created and what needs to be in them. And by its design, it was supposed to have some independence from the government. We thought that was a step forward, and it was, because in Ontario, the standards development process has been too mired within the provincial bureaucracy, and that has slowed and weakened it. As well, the federal government, or the federal bill, Bill C-81, included the creation of two other new public officials or offices. An accessibility commissioner within the Canadian Human Rights Commission, who would have certain lead enforcement responsibility, and another official called a Chief Accessibility Officer, who would report to the responsible minister with the function of giving both advice and periodic reports on how we're doing. So this overall had some key ingredients. CASDO could recommend standards. The government could then adopt them as is, or amend them if they wish, or not adopt them at all. That had potential. However, there were a number of problems with the bill. I'm going to summarize some of the leading ones, but we ended up detailing them in a brief that was over 100 pages and asking for as many as 97 improvements. You don't have to resort to that number of pages or amendments when everything is just fine. The first problem with the bill is that while it said it had the goal of a barrier-free Canada, it actually never set a deadline. Not only that, it talked about the progressive realization of an accessible Canada. And the word progressive realization, we worried, was a signal to go slow rather than a deadline that would motivate us. We said that the law was, later when we were to come before Parliament in the fall of 2018, we said that the law was strong on good intentions, but weak on implementation and enforcement. For example, the law enabled the creation or enactment of accessibility standards, but it didn't require any to be ever made. And if they're not made, then most of the rest of the bill will basically be sitting there kind of waiting to go into action. As well, the bill splintered the implementation and enforcement of the bill over 3 or 4 federal agencies. This is what was foreshadowed in the summer of 2016 by the government's discussion guide before it even consulted the public. Accessibility standards regulations, if they get a recommendation from CASDO, this advisory body, 3 different bodies had power to make the regulations they recommended. If they relate to federally regulated transport, the Canadian Transportation Agency, or CTA. If they're related to radio, television, or telecom, it's the CRTC. And for everything else, it's the federal cabinet. Well, that meant, from our point of view, first that we had to run around and ask for 3 different bodies to essentially do what could be the exact same thing. Try to persuade 3 different organizations. That's tripling the advocacy efforts that we had to undertake. And ours is a community that's not exactly flush with resources to do this. Most people with disabilities live at, or a substantial number live at or below the poverty line, or dependent on social assistance and are either unemployed or underemployed. So that was a horrendous enough burden. But when it came to enforcement, the bill's enforcement was actually splintered over not 3, but 4 organizations. The CRTC would receive complaints relating to transport. CRTC relating to the broadcast or telecom organizations they oversee. If it's relating to federal employment, there's a federal employment tribunal that would hear cases. And everything else, you getting dizzy, would then go back to the Accessibility Commissioner. Now, that is complicated enough. But it gets more complicated because there are overlapping responsibilities. There are some things which Bell Canada would have to do and report to the CRTC on. And under the bill, there are other things that Bell Canada would have to report or be overseen by the Accessibility Commissioner. And if you were to ask me, someone who teaches law and has practiced law and has done some specializing in this area for some time, I can't keep it straight. And if I can't keep it straight, I got to figure others with less opportunity than I've had to figure this out are going to have trouble keeping it straight. The bill was over 100 pages long. It is really complicated, and complicated laws are less effective at achieving their goals. There are other problems. The bill prescribes that obligated federally regulated organizations have to make implementation plans. Now that's good, but it didn't require them to be any good. And it didn't let us as individuals complain if they weren't any good. And furthermore, it divided them up so that, again, Bell Canada might have to make one plan on some accessibility issues and report that plan to the Accessibility Commissioner for oversight. And another part or aspect of their operations, they would make another plan and report that to the CRTC. And that, again, creates added cost burdens, greater complications, and slows progress. The other 2 main criticisms, there were others, but the other 2 main criticisms of the bill were these. One is that it was weak on ensuring rights, but it was really strong on providing chances for exemptions. It provided that a number, not all, but a number of the duties under the Act could be the subject to sweeping exemptions granted behind closed doors with no public accountability. And as well, the bill did not harness all the levers of power the government could harness. The example I gave earlier was the lead one we and others focused on. It did not require the government to ensure that public money is never used to create or perpetuate barriers against people with disabilities. So the most it said was that in one category of public spending by the federal government, procurement spending, the government could create an accessibility regulation, could set rules, but it doesn't have to. But as for other federal spending, like money that it gives others or itself to build infrastructure, it was silent. So what happened? Well, the bill got first reading automatically on the last day before the House rose for the summer in 2017. And for the next several months, folks within the disability community got very busy analyzing it, trying to figure out what it meant, and writing briefs to submit to the government. The coalition I lead is no exception. But what ended up happening within the community, we have a very diverse disability community spread out over the country, of course, both in terms of individuals and organizations. But a lot of the effort ended up being concentrated among two organizations, the one that I lead, the AODA Alliance, and the Arch Disability Law Center here in Toronto, a fabulous legal aid clinic that does excellent litigation and law reform work. And we ended up collaborating, doing our own analyses, and releasing them, but collaborating and thinking problems through debating and seeing if we could maximize common ground. And a number of other organizations ended up relying on what we each had to say. So what happens then? The next step in this process comes in the fall of 2018, when the bill comes back before Parliament, before the House of Commons for second reading. So, by the way, if you don't know much about these procedures, a lot of people don't know much about these parliamentary procedures. We teach you court procedures in law school, but not legislative procedures. And I had only worked in the provincial sphere, so with the able assistance of some Osgoode students volunteering for us, we released a guide, an introductory guide for beginners to federal legislative procedure. In other words, how does a bill get through Parliament? I know it doesn't sound super sexy, but it's really important when you're going to go through this process. And part of the responsibility of those of us doing advocacy is to educate our communities on the steps we're going to be going through. So the bill comes back for second reading. So what happens at second reading? Unsurprisingly, the government says their bill is great. The New Democrats and Greens, relying in no small part on the critiques that had been made public by my coalition and by Arch, said the bill doesn't go far enough. The Conservatives divided. Some members of the Conservative Party thanked the federal government for bringing a bill forward, said, yes, we've got to do more in this area, and some of them pointed to some of our criticisms of the bill, saying it needed to go further. And others within the Conservative Party were saying, what do we need this for? This is too much government. This could be, there's ways to help remove these barriers without all this new legislation and new regulatory machinery. And we're nonpartisan in our advocacy. And one of our goal was to get the law strengthened and passed, but we also wanted it unanimous. We didn't want to run the risk that a successive government might be elected that would repeal what we had won. So the next stage in the process that becomes really important are public hearings. After the bill passes second reading, it can be assigned to a committee of the House of Commons to hold hearings. We and others had been pushing to assure that this would happen. The government agreed, and in October of 2019, the government invited any number of disability organizations to appear to take part in public hearings. This is a really interesting experience from my perspective, because when we're working at the provincial level here in Ontario, the coalition I lead is the AODA Alliance is reasonably well known for its advocacy in this area, and everybody does their own thing, but we've been known as a place to turn to for direction in this area, and people will often agree with what we have to say and seek our input. When it comes to the federal sphere, there are folks all over the country, and there was no realistic way to pull everybody together and get everybody sort of reading from the same common agenda. The efforts were made to bring advocates together, organizations together, their government relations people together, and there was a lot of informal conversing going on and information being exchanged. But this was all happening under relatively tight timelines, so it was not exactly kind of thing where you could get everybody in a room and sort of all in favor of Amendment 3, say aye and so on and whatever. And frankly, achieving unanimity is not even possible. So the idea was to try to achieve harmony between the different perspectives being advocated. So what happened when it came before the committee? Well, this is last fall. This is where the message ramped up, not just in the positive, but in the negative and where things need to be improved. And over probably about 3 weeks of hearings, the standing committee heard from group after group that was saying, thank you for the bill, congratulations, we need it, it's overdue, but it needs improvements. And that echoed, and different groups would emphasize different points, but there were common themes. And a number of them are the ones that I've highlighted. There's no end date. It gives the government a bunch of powers, but not duties. If it's not mandatory that the government do certain things to implement this bill, there's the risk they'll never do it. I'm speaking in a law school university setting. The way I translate that into your world, it's the equivalent to the university or law student question, is it on the exam? If it isn't, I'll worry about it later. Well, we wanted the key things to be on the legislative exam. And we had a lot of experience from Ontario particularly that the government can be very excited and opposition parties can all congratulate themselves about passing strong legislation, but then implementation can slow to a crawl. And so we knew that we needed more in the bill to speed it up. There was increasing recognition that the splintering of the legislation was a serious problem, and the other issues that I've identified. But also what came out, and this is important for me to emphasize because it carries on to this day. In the bill, there was a provision, Section 172, for those who are section number buffs, which was going to re-entrench or repeat a provision in the Canada Transportation Act that we had serious trouble with. It's a provision that we haven't seen anywhere else in this entire world of human rights and accessibility. Anywhere else that we have been involved, including in Ontario, when you create a power to make accessibility standards, they can never take away anybody's human rights. So if you create in Ontario a regulation on accessible transportation, if it's weaker than what the Human Rights Code would guarantee, the Human Rights Code would prevail. And that's the case across the board with one exception. And that's under the Accessible Canada Act as proposed in relation to transportation, a provision that had been in the CTA and which was being preserved or being perpetuated instead of being repealed. Section 172 basically said if the federal government, if the CTA passes an accessibility regulation on transportation, it sets a standard. It says, airlines, you got to do X. Then that's all they've got to do. So let me give you a practical example. Imagine, this is a hypothetical, but it illustrates it. as a blind individual, when I'm flying without on an airplane on my own, not with other friends or family, the airline is expected to provide someone to guide me from the airplane after we land, to get my suitcase, go through customs, and go out and get a taxi or whatever to get home. And it's a service, this is provided around the world. Now, the problem here in Canada too often is they take way too long, and you can spend a lot of time waiting. Now, if the CTA, according to Section 172 as drafted, if the CTA provided that they have, let me say, 5 hours to get me off the airplane and out of the airport, which is like a ridiculously long time, then as the bill was proposed, I would not be able to file a complaint under the CTA legislation or the Accessible Canada Act saying that the airline should have taken less time. As long as they took less than 5 hours, they were fine. So no matter how weak the regulation is, once it's passed, that's all you can complain about. And we and others said, that's just wrong. It's especially wrong when it's made by a federal agency that does not have a great track record on accessibility, and from our perspective, we worried was too close to the transportation industry rather than the accessibility world. So we wanted it repealed. And in fact, when I got, so this was a message that came from a number of organizations. So what happened at the hearings was you get a few minutes, maybe 8 or 10 minutes to make your pitch, and then there are questions. So what happened when I got there? One of the things that was exciting from the perspective of Osgoode, I had a team of Osgoode students who'd volunteered for us through the Osgoode Public Interest Requirement, and 2 actually got to come to Ottawa as part of this exercise and to be with me throughout the hearing that I appeared on. Got to present, and I had asked to appear on the last day of the hearings. Why is that? I wanted us to be the closers. I wanted to see what each of the other groups were saying, and then we'd be in a position to say, okay, that's great, that's what they all said, but here's what we want to add. I wanted to pick up on the issues that no one else had addressed. I also want to do it because as hearings are going on, opposition questions and government questions are really important to follow. From the opposition, you get to see which of your criticisms of the bill they've already picked up on. And from the government, you can see from their questions what kind of defenses they're trying to make to the legislation, or do they seem to be ready to be more flexible and responsive to making changes. So I appeared on October 25th, 2018. Thanks to the wonders of modern technology, we could, it's not only streamed live, but we could capture the video, make it available, tweet about it, let all sorts of people find out about it, and so on. Pardon me. And our message that day was to zero in on a couple of the key problems with the bill, particularly the splintering of the legislation and the lack of the mandatory duties to implement it. But we found out through questions, it gave us a chance to answer the kind of questions that the Liberals were ready to ask us. Now remember, we're nonpartisan. I'm referring to the party by name. We're not pro or against any party. We're trying to get somewhere. Well, they started saying to us and to me, well, you can't really set a deadline for accessibility, like an end date, because the concept of accessibility keeps evolving and changing over time. And so how can you possibly anticipate that? And I mean, I got to tell you, it was like the first time I heard this. And you can't quite say, give me a break. But in effect, I wanted to say, like, give me a break. I mean, the notion of accessibility, like we know people in wheelchairs can't go upstairs and like they need a ramp. And we also know that like blind people need Braille and the elevator buttons. There's a whole lot we know. Most of it we know. The vast majority of it we know. Something new comes up, we'll figure it out. You know, mobile apps come along, now we figured out what they need for accessibility. This is not rocket science. It's not like this is all some big conundrum and, oh, we'll never figure it out, so we should never have a deadline. Anyway, after the hearings, the next opportunity I had, fortunately, was to go and meet the minister herself, Carla Qualtrough, who I met a number of times. And I got a lot of respect for that day. Now, I don't make public the content of these meetings because I want to be able to have a fair discussion and a candid discussion. But I can tell you that after the hearings and after meeting the minister, I did not have a confidence that we were going to see amendments coming forward from the government that were going to fix a number of the serious concerns we had. The government's public line was, the disability community likes this bill. So we needed a strategy, and we needed one fast. And what happened literally on 24 hours after the day that I appeared before the committee is a small number of us who had been involved in advocacy with sort of some collaboration together, particularly from the Arch Disability Law Center and the Council of Canadians with Disabilities. We collectively came up with a strategy. We can't form a whole new organization or something like that. We don't have the time. But what we can do is write an open letter. So we drafted an open letter to the government and tried to crystallize in it 8 or 9 major requests that we wanted to see in the amendments. Not that they were the only ones, but at least the ones that should get the most immediate attention. Now, some of them are the ones that you've heard about, that I've talked about up to now. But there were others that were coming from some other organizations that were getting a lot of traction. One was the deaf community was very eager to have sign language recognized as the official language for deaf people. And in some other countries, sign language is recognized as an official language. And so that became one of the issues. Issues were also presented about the need to recognize in the bill some specific distinctive ways in which accessibility can play out for Indigenous peoples in Canada, for people who are face multiple bases for discrimination. The big word they use is intersectionality, and so on. So to get as many people on board, we tried to come up with a list that was doable, but not exhaustive and endless. And this is coming, you're hearing the lecture from the guy who wrote the 100-page brief with the 97 amendments. So getting it down to 8, and it wasn't just me, it was a collaboration, was a big deal. And within about 3 or 4 days of drafting this, thanks to the miracle of email and other modern technology, we were able to collectively release this on October 30th. This is 5 days after I appeared before the House of Commons, with fully 34 disability organizations signing on. And over the next weeks, that grew to 95. So the open letter, it wasn't an organization, it's a letter with a whole lot of major players signing on. And that became, if you will, it's not a legal document, it's not a factum, it's not a formal brief, it has no juridical status, but it became perhaps the most powerful statement of what was needed. So that a week or two later come the amendments, and the committee holds what's called clause-by-clause debate. Let me take you to that step. And this is when the government and the opposition members can table amendments, they can debate them, and then vote on them. Now, it's a majority government, so the government of the day, the Liberals have the majority of seats, they got the majority of votes, they decide what passes. Now, I've been through this process in Ontario. In Ontario, we've been able in the past, when the AODA was before Parliament in the legislature in 2004, 2005, before amendments are introduced or when they're introduced and before they're debated, the parties make public the text they're recommending, they're proposing. So we could get it, we can review it, we can go public with it, post it online, we can tell people this is what each party is going to do. The federal government or federal parliament has some tradition against this. We asked all the parties, can you send us the amendments you're going to introduce? We were told, we're not allowed to. It's contrary to parliamentary privilege. Parliamentary privilege? Is it a privilege to keep it secret? These are what they're proposing. I mean, it made no sense. But what got worse is that if you watched the debates in the committee, they were time limited. There was a limited amount of time available. And in Ontario, when an amendment was proposed, at least when I've been involved in legislative proceedings, the member of the committee that's introducing it will say, I move that section so-and-so be amended by adding the following words. The federal standing committee in the House of Commons didn't do that. It said, okay, now motion 3, I move motion 3. You're watching this on TV, you have no idea whatsoever is being proposed. And if somebody else says, well, I don't agree with it because I don't like the word but, genuinely, it's absolutely an impenetrable process. Having read the Hansard, the transcript of the debates, you cannot tell what they are doing. But they voted on something. We do know that the opposition, NDP and Conservatives, introduced very substantial packages of amendments drawn in substantial part from the submissions from the AODA Alliance and the Arch Disability Law Center. Not exclusively, but predominantly. The government introduced a far narrower package of amendments, and as is, you can expect in majority government, all the government amendments pass, and I don't know if absolutely none or virtually none of the opposition amendments passed. But this has longer term significance. Let me just briefly tell you the core things the government changed. They changed the goal of the law from saying the progressive realization of an accessible Canada to the realization of an accessible Canada, and that was a step forward. But the federal government still would not include a deadline. They did not require the government to ever enact any accessibility standards. They did require that one regulation must be made within a couple of years of the law passing. The law specifies the exact timeline by cabinet, by the CTA and the CRTC, but they relate to procedural things, whether it's the kind of reports that must be filed or the kind of feedback mechanisms for complaints on accessibility that have to be established. They're processing things. They don't actually still require that any accessibility standards regulations are ever made that can be enforced. Now, it's better there's something rather than nothing, but we're still missing out on a key requirement. I talked earlier about the fact that the bill gave sweeping powers for the federal cabinet or for the federal government or the CRTC or the CTA to grant exemptions. These were narrowed only to the extent that if an exemption is granted, the granting body must give reasons, and it only lasts 3 years. Now, again, it's a step forward, and it's helpful, but it's nowhere near what we needed. And most blistering, the government did not explain why the government had to retain the ability to exempt itself from the rules it is itself making and there to enforce. There were some other procedural and other amendments. I'm just summarizing the key ones, but suffice it to say that the process of having this bill debated at second reading and then subject to debate to public hearings was a constructive process from our point of view. Let me move you briefly to third reading, because there was an important thing that happened at third reading from the point of view of community organizing strategy. At third reading, the government, of course, came in and said, it's a good bill. And the New Democrats and Greens again echoed their criticisms of the bill, invoking its weaknesses, pointing to amendments they had proposed, the NDP had proposed, referring in part to the AODA Alliance or Arch or others as supporting their criticisms. But so that was very similar to what you would have heard at second reading. But the big change was the Conservative Party. On third reading, the Conservative Party said, we support the bill, but it's too weak. There wasn't a major thrust of saying we don't need this at all. The Conservative Party said they're going to vote for the bill, even though they think it doesn't go far enough. And they also said, in a line that I've since retweeted about a zillion times to Tory candidates, to remind them that if they are elected, the Tories will treat it as a priority to strengthen this bill. So from our point of view, to sum up, the journey through the House of Commons accomplished several things. It saw our community substantially form a consensus around this open letter I described. It led to some actual amendments. It led to a fairly clear agenda for where more were needed. It garnered support from some of the from opposition parties, and it got the one party that was on the record as divided at second reading over whether they need the bill at all, to be united saying, we need the bill, it needs to be strengthened, and we'll do it. So those were all, from the advocacy perspective, major points of progress. So just before we take the break, I want to talk to you about why this story didn't end. Ordinarily in Canada, if this was a provincial law, that would be the end of the story, because we just have one house in our legislature. We don't have an upper chamber. And second, in the federal sphere, we do have a Senate, but you'd figure, like, why bother going to the Senate looking for improvements? Because they're not elected. Whatever they do has to be approved by the House or it can't pass. And so why don't you just take what you got and run with it? Well, that argument made sense to some people. And in fact, it made a lot of sense to me at the start of October last year. But some of my colleagues managed, without a lot of work, to say, to make the contrary argument, which is, look, the Senate has the power to make improvements. Why should we give up? Why shouldn't we try to get more? The bill as written has helpful components, but is still too weak, and we need improvements, so why not give it a run? Now, this led to a real interesting tactical challenge, because the federal government, of course, didn't want the Senate amending the bill. They never do. Whoever the party is in power, they've passed what they want to pass. They've used their majority. They've gotten it. Why would they want the Senate messing around with it? And the Senate, there were some from within the federal government who were kind of tacitly putting out the word within our community, saying, like, don't push for the Senate to change it, please. One referred to it as, I think, the nuclear option. And the reason some within the disability community got worried about this was timing. If it was the first year of the government's mandate, there wouldn't have been a timing worry, because the bill could have gone to the Senate. If the Senate makes changes, if there's time for it to come back to the House of Commons, the House of Commons can either ratify those changes, or the House of Commons rejects those changes. The bill can go back to the Senate, because then the Senate has to repass the bill without the Senate amendments. A law is not passed until both houses pass the identical law. We'd have all the time we need. But the worry was that the bill hit the Senate in January or February of 2019. An election was coming up, scheduled for October of 2019. And there was a worry among some that if the bill did get amended by the Senate and it went back to the House, if the House did not take up those changes in time before the election's call, the bill dies. Or if the House takes up the bill and rejects the Senate amendments, if there isn't enough time for the bill to go back to the Senate again to pass the bill unamended by the Senate, the bill dies. So some were worried that an effort to get changes by the bill to the bill by the Senate could lead us to lose what we had secured so far. This led to an obviously interesting challenge, which is, did what we get, is what we had already gotten so good that it wasn't worth the risk, or is the risk that big? And for the answer to those questions, come back after the break. All right, welcome back. Two things I just want to mention before I dive back into the narrative. One is if anyone wants to learn more about this, our specific roller coaster ride on the Accessible Canada Act is all available on one page or through one page on our website. If you go to aodaalliance.org/Canada, you can see all the major documents. I'm talking about the briefs, the debates, some of the news coverage when we rarely got any, and so on. And the other is if you want to get email updates in the future on how this campaign is waged, just send a request to this email address, aodafeedback@gmail.com, aodafeedback@gmail.com, and all you got to say is sign me up. The other thing is I want to qualify that I'm giving a kind of a verbal memoir from my perspective as chair of the AODA Alliance, and I don't want to over-exaggerate either my role or that of my coalition. We were a player. I think we were a helpful player, but there were many players working on this around the country. And everybody contributed in important ways. So let's now dive into the Senate. So let me just mention to you a few challenges that we were facing from the outset when it came to dealing with the Senate, beyond the timing concerns that I mentioned just before the break. And those timing concerns were significant. The first of these challenges is the Senate is unelected. And that means senators don't have to take your phone call or worry that if they don't talk to you, that can affect their electability. And from the senators, I had no prior experience with the Senate. Through the several that I got to speak with, I was impressed to a person at their dedication, their hard work, their commitment to fulfilling their important role. And as well, I came to realize that theirs is a part-time job with a lot to do. So I talked to some senators who would say to me, like, I'm interested in what you're talking about, but I've got a bill I'm bringing forward. I don't have time for anything else, or things to that effect. And I'm not saying that as a criticism. To the contrary, I'm just saying that it's also they don't have party structures behind them. The Tories still have some degree of a party structure, but there are a bunch who are considered independent senators. So each of them may have an assistant in their office, but they don't have like a ministry with a bunch of policy researchers who could look into this. What that meant, and this will crystallize the nature of the challenge, when I was able to get a senator on the phone, and I was privileged enough to be able to get through to several, and they were generous with their time and very attentive. I was, to a person, really impressed with the folks I got to speak with. But you might get 15 or 20 minutes on the phone. And in that 15 and 20 minutes, you got to do the following. Number one, explain to them what the 110-page Accessible Canada Act is for, what it does, and what's wrong with it. And then you got to explain what specific changes you'd like and why they are a priority among the list of ones that are needed. Then you've got to try to persuade them that the worry about the bill dying if the Senate amends it is something that they should not allow them to freeze them in their tracks. That's all in 15 minutes. Now, I had some training for this because I've appeared a good number of times in the Supreme Court of Canada, sometimes an intervener where you only get 10 minutes. So 15 minutes may seem luxuriously long. But nevertheless, it was a daunting advocacy challenge. Nevertheless, a number of us were engaging in this advocacy. At the other major challenge we were facing beyond these, remember I said that during the consultations before the bill was introduced, the government federal government had provided funding to the disability organizations to engage in consultative activities. Well, what that did is it led a number of organizations to go and do outreach, And later it led to a bunch of them clustering together into a coalition of sorts that was called the Federal Accessibility Legislation Alliance. Now, it had initially come together before the bill got introduced, from what I am told. We weren't part of it. But after the bill was introduced, I gathered from the website of FALA that they were getting federal money to help them advocate on the bill as it was going through Parliament. And one of the things FALA was doing appears to have been a campaign of emailing senators to say, pass the bill, not referencing amendments. And I'm a firm believer in democracy, and people are free to do this kind of lobbying. And that's important for people to have their voices, whether one agrees with them or has a different view. But I describe it to you because when I got on the phone with senators, some of them would say, I just want you to know I've gotten 200 emails, all in exactly the same wording, saying essentially pass the bill. And I would have to try to, or others who were trying to ask for amendments have to explain, look, people are worried about not losing the bill, but let's come up with a package of amendments that's doable and get it through the Senate quickly enough that the House can deal with it. And this was the first time in my years of disability advocacy that we essentially had legislators quoting others from different perspectives in the advocacy community, that we had to overcome their arguments, not just arguments from public servants or others. And heck, that's what advocacy is all about. You find out what case you got to make, and you make the case. So what happened? The bill was debated in the Senate. They go through the same first, second, and third readings. The bill was debated past second reading and was sent to a committee for hearings in April. And that's when the action started. So to get ready for this, I and others who were doing advocacy and wanted to push for amendments were putting our heads together to make sure that we pushed for a short, compact list of amendments. Because now we're not before the House of Commons where we might get a broader number of amendments. And believe me, when you only have 10 minutes or 8 minutes or whatever before a standing committee in the House of Commons, you could only pick the priority ones, but you can table all of them. But in the Senate, we knew that the issue of the bill dying was increased if the Senate were to make 40 or 50 amendments. On the other hand, and the senators knew that too. And I was told more than once, come up with 1 or 2 or maybe 3, but keep it short. And a number of us from Disability Arch and other CCD, other organizations, were all thinking in those terms, wherever you were on the spectrum of advocacy on this issue. So we released a brief on the 29th of March that had a much shorter list of asks. And even that list got shorter within 2 weeks. Because what happened were 2 things. First, on April 3rd, the committee began its hearings by inviting the minister, Carla Qualtrough, to appear before the committee. And this is not unusual, where they'll have a minister, before they hear from community groups, just explain what the bill's about, what it's there for, and answer questions. Well, fortunately, through the advocacy efforts by my coalition and others, a number of the senators were well prepared for this. And they asked a number of very good, respectful, but pointed questions to the minister. It wasn't like a cross-examination, but going back to my days as a lawyer in a courtroom, it felt like a cross-examination because it's a chance to try to get some answers. So the minister was, for example, asked, why isn't there an end date for achieving accessibility? And the minister gave her answer. She said 2 things. One, the answer that you heard me refer to before the break, that accessibility is some sort of moving target. And the other she expressed was a worry that if we set a deadline, 20 years out or whatever, that everybody's going to slow down rather than speed up. And when it came to the splintering of the legislation among multiple agencies, the CTA, the CRTC, and so on, the minister, I think, fairly conceded that if she was starting to draw this law with a blank piece of paper, as she put it, she wouldn't necessarily draw it this way. But they have an existing set up government with a series of agencies. They got to work within them. Now, that, by the way, didn't sell me, because applying accessibility means starting with a world full of barriers, figuring out which ones to remove. And those agencies have been acting to us kind of like barriers. And the answer, wow, but they're barriers. But, you know, there are barriers, so we got to leave barriers, is not much of an answer when you're trying to achieve accessibility. I'm being a little glib, but only a little. But also the minister tried to say, well, there's a reason for dividing it up, because here's a reason why you need a division of responsibility between the CTA and the Accessibility Commissioner in regulating different parts of, for example, an airplane seat. And she gave this example, which we were later able to prove was actually completely wrong under the legislation. She was confused about who has authority over what. And I don't fault her. I've got a lot of respect for her. It's an extraordinarily confusing law. It confuses me. It confused the minister. I fear it's going to confuse everybody. That's why we wanted it simpler. She was asked why they don't require that, for example, if federal money is spent on infrastructure, that they ensure that it's never used to create new barriers. The minister said they've pushed federal jurisdiction as far as they can. Respectfully, the feds have a broad spending power. She seemed to be conceding implicitly that laws like the Canada Health Act must be unconstitutional. That's me talking. By suggesting that they can give money to a province, say, go ahead, build a hospital and build it however you want. It can be as inaccessible as you want. We can't say a thing about that. That seems untenable. Anyway, this was really helpful because our appearance, my coalition's appearance, was just a few days later. She appeared on the 3rd of April. I appeared on the 11th. That gave us a chance to rebut her position, albeit within extraordinary time limits. But between her presentation and my appearance on the 11th, that's from the 3rd to the 11th, came one of the most interesting lawyer writing or law writing challenges I've ever faced. Because it occurred to a number of us that it's not good enough to table a brief. We need to table the actual amendments. We need to walk in the room with a piece of paper with the actual wording we want. And it's got to fit on no more than 3 or 4 pages. And it's got to be self-explanatory. It's got to be something that a busy senator who may not have gone to law school, who hasn't had time to get briefed on these things, can read, understand, and agree with and go, why the heck don't we do this? And we had about 4 days to do this. We did it. And that document was tabled. You can see it on our website. I can't tell you it's perfect. I'm sure with more time, we might have thought of other stuff. In fact, I've caught some errors already. Didn't matter because it was errors and provisions they didn't adopt. But it became a very important document as the Senate considered what amendments to make. Now, we appeared. I focused on just a couple of priority items. I focused on unsplintering the legislation's diffuse administration. I focused on the problem of not imposing restrictions on the use of federal public money when used for infrastructure and so on. And I focused on getting rid of Section 172, this totally inappropriate provision that gives a gift to federally regulated transportation providers once they convince the CTA to pass a weak accessibility regulation. That's all they got to do. So other groups appeared, and this was what was very interesting. Remember I said that this organization, this sort of ad hoc coalition, the Federal Accessibility Legislation Alliance, by the way, a number of friends in that alliance, it's not like we don't talk to each other, but had been mounting this email campaign saying, don't change the law. Well, any number of their organizations had signed our open letter the fall before, and any number of their organizations, a number of them, came before the standing committee and said, please pass the law, please pass the law, please pass the law. And by the way, if you're going to amend it, here are amendments that we'd like, which was helpful to us because we could say, look, there's a consensus here. People want the law passed, but they want it fixed. And the Senate got that message. May the 2nd came around, and that was the morning set aside for clause-by-clause debate. In this modern age of tech, I could sit at home. One computer was running the live stream, and the other computer was me live tweeting it on Twitter. And there were times we scored things. There are other times I didn't know what they voted on because you couldn't tell till we found out later. But in effect, it was really interesting because remember, one of the things about senators, not only do they not elected, because there isn't the usual traditional party structure, any senator can table an amendment. They could all agree that something's a good idea, but if they don't do it, if nobody tables an amendment, they might all think it's a good idea, but nobody will vote for it because it's not on the table. So we had to spend a certain amount of time, we and others, trying to get through to senators and say, look, could somebody, you got these 3 pages for 4 pages, they're good ideas, you like them. Could somebody please put them on the table, even if you vote against them? Well, fortunately, the Senate Standing Committee, which appeared from the outside to be a very collegial bunch, had a number of different members introducing amendments, including the senator who was the liberal sponsor of the bill. Let me just take you back a step and explain the process. One senator from the governing party is chosen or agrees to be the bill's sponsor. They're the one who moves the bill. They're the one who introduces the bill. In this case, it was Senator Jim Munson, a former CTV journalist, and he was both the one who introduced the bill for first and second reading, but he's also the one who was on this standing committee. So he actually came in and he himself tabled some amendments. It was obvious if he was tabling them that the government had agreed to them. And in other cases, others introduced amendments, and whether or not the government liked them, some of them passed. Now, the committee was absolutely driven by keeping the number of amendments short. On the last day of hearings, after I appeared, they turned to 3 deputants presenting together from 3 different perspectives and said, if there's one thing we're going to do, what would it be? And one of them said, David Onley, our former lieutenant governor, said, setting the deadline, the end date for accessibility. By the way, in our 3-pager, we'd held off naming a year, figuring let the government come up with a year they could live with, but they wouldn't, so we came up with a year in our 3-pager. We said 2040, 21 years out. AODA had given 20 years, we figured 21 years, it's a nice round number. 2039 might sound weird, so we picked 2040. David Onley said, top priority, past 2040. And then the other 2 deputants that day said, yes, we agree. It's got to be a mandatory deadline. And so the committee, when they got to voting, passed several things. I'm going to just summarize a few. But it was really a step forward. And sitting there at home watching this live streaming, I got to tell you, it was a pretty exciting day. To the extent I could figure out what was going on in real time. First, they did pass the 2040 deadline. This alone was a big deal. We've now got a law aiming to achieve a barrier-free Canada sometime, whenever, to a law that set a deadline of 2040. And that starts the clock running immediately and can be the focus of all of our efforts. Next, there was the don't worry, minister provision. She had worried that this could slow people down, so we had drafted in our 3-pager a clause that would say, but this 2040 deadline cannot be used as a reason to delay progress. I'm paraphrasing, the committee passed it. Don't worry, minister, it won't slow things down. And I don't mean that glibly. I mean genuinely. She was worried about it. It's a sincere concern, and we wanted to address it. They did adopt 2 amendments that were coming from others within the community. The recognition of sign language, not as the official language of Canada, but as the language used by deaf people, referring to various forms of it. And also establishing the principle of intersectionality that I referred to earlier. We were concerned, I haven't emphasized this as much, that we should have protection in the law that provides that nothing can be done to cut back on our rights under this law, and that whenever there's a clash of laws on accessibility, the stronger one prevails. The AODA in Ontario has a specific provision, Section 38, that says if there's a clash between the AODA or its regs or regulations or any other law on accessibility, a conflict, the stronger one, the most pro-accessibility one prevails. We wanted something like that there. In this law, the minister agreed to I guess effectively, because I believe it was Senator Munson who brought it in, a law that basically said that nothing in the act could essentially, I'm paraphrasing, reduce the duty to accommodate people with disabilities in human rights law. Helpful, doesn't go all the way that we wanted it to go, more in a minute on that, but it does help. With respect to the other major amendment, there are others, but I'm just doing the key ones that I can squish into the time we have. The other one related to the question of Section 172, this gift to the airlines or federally regulated transportation providers. Now, we wanted it just repealed. And if it was repealed, what would happen is the CTA, Canadian Transportation Agency, could pass regulations on setting standards for accessibility in transportation, that's fine. But individuals could still file individual complaints for undue barriers under the Canada Transportation Act, and we wanted it clear that those regulations are a floor, not a ceiling. But what the government came back with was something that didn't go all the way. Helpful, but didn't go all the way. What they did was if memory serves, it's Senator Munson himself who brought it in, the wording provided in effect that if you can always bring a complaint for undue barrier with respect to transportation. CTA can always make a regulation setting standards with respect to transportation. If a standard is set, you can still bring a complaint that you are insisting that an undue barrier exists, even if it's compatible with the regulations. So even if the standard says the airlines have 5 hours to get David off the airplane and through security or through to get his baggage and out into a taxi, and if he complains that it took him 4 hours and that's ridiculous, I can still complain about that and show they should have gotten it done in, I don't know, in half an hour, 20 minutes, 1 hour. You didn't need 4. And they no longer have an absolute defense. But what's left is, I can't recover damages. In that scenario, if the airline or other federally regulated transportation provider is complying with the regulations, they are immune from a damage claim. They can be ordered to clean up their act. They can be told never do it again, but they don't have to pay a dime. I believe, and we believe, that's just unreasonable, unfair, unjustified, and ultimately discriminatory. But it is better than where we started. So let me finish quickly the journey through the Senate. The Standing Committee finished its vote on the 2nd of May, and the bill came back to the Senate for third reading. Unsurprisingly, the bill passed third reading with the amendments as written. Nobody made an issue out of it. The Senate, I gather, leaves the heavy lifting to the committee that's doing the work. Now we come to the third last round in this engagement, or the third last twist in this roller coaster ride. This bill has now passed the House on 3 readings unanimously, and the Senate with amendments now unanimously. It's now it passed on the 13th of May, it's got to come back to the House of Commons. The House of Commons only has to take one vote on the amendments. It doesn't have to go through 3 readings and have hearings and all that sort of stuff. And an election is looming. So the big, open, huge question is, will the House pass the Senate's amendments? We now turn to a campaign where our sole objective is get those amendments passed. And this is a really interesting dynamic because we weren't worried about the opposition parties. The opposition parties had supported, at least the NDP, the Bloc hadn't taken a particular position on it, but the NDP, Greens, and Tories were on record saying this bill needs to be strengthened. So we were not worried that they were going to substantively oppose these amendments. The question was, would the Liberals agree with them? So we all mounted a campaign to basically get the Liberals to pass the Senate's amendments. Remember, if the House passes them, one vote, it's done. It's the law. If the House defeats them, it goes back to the Senate for another vote on the bill, unamended, with the time constraints of getting it done before the election or the bill dies. Now, I frankly still think there would have been time to get it back before the Senate before the election, but in any event, now, remember I said earlier there was this division among some about whether it was strategically wise to go to the Senate for getting amendments. Some feared it would kill the bill. That debate is now over as of May 14th. What we did was we wrote a second open letter, spearheaded again by the Council of Canadians with Disabilities, an advocacy group, the Arch Disability Law Center, and my coalition, the AODA Alliance, the coalition I chair. And what we said was basically, pass the bill as amended, please. And all of a sudden, there was no division in the disability community because everybody wanted it passed. And everybody wanted it to not die, and everybody was supportive of the amendments. Those who didn't want the Senate making amendments earlier, said they didn't, weren't saying they think the bill did everything they needed. They just didn't want to run the risk of losing the bill. Now, oh my God, we could lose the bill worry was only tied to one thing. It was tied to the possibility that the Liberals would not approve the Senate amendments. So we write this open letter. It's signed broadly, including by the Federal Accessibility Legislation Alliance. We're working together. It's what advocacy is all about. And this is then the subject of tweeting and advocacy and all that kind of good stuff. And the government, the Minister Qualtrough and the government was very silent. They were not saying what they would do. And the pressure was on. And finally, the minister announced on the 22nd of May, if memory serves, the 22nd of May, yes. On the 22nd of May, the minister announces on behalf of the government that they will support all the Senate's amendments, which really meant this thing is going forward. So it comes back to the House during the next week, the last week in May, which happens to be National Accessibility Week. Nice symbolism. And the bill passes unanimously with all the Senate's amendments, proclaimed in force in early July. That's the third last twist and turn. An important one because we've won some things. We've got a national accessibility law. It's got a stronger purpose. It's got some strengthened provisions. It's got some helpful ingredients, but it still suffers from key weaknesses. It still does not require a single accessibility barrier to ever be removed. It's still got the splintering amongst different agencies problem. The government had said in the face of the criticism that the bill is splintered between multiple agencies that we will ensure there's no wrong door. Wherever you take your complaint, if it's the wrong agency, we'll send it to the right agency. We said, yeah, but we want to make sure that once you get through the door, you don't have to face different roller coaster rides depending on the agency. And even that we weren't able to secure. So we now come to the second last twist and turn, and that is the federal election of 2019. One of the things you learn at doing this kind of community organizing and advocacy, when you do a court case, you argue at trial, you argue at appeal, you go to the highest court, or you refuse leave to appeal, it's over. You've done what you can do. This ride's never over. It's never over. And so we went into the AODA Alliance, went into this election saying, all right, now let's ask the political parties what they will do if elected, either A, to implement the law, or B, to strengthen the law. We had some of the parties, particularly in opposition, saying, hey, if you elect us, we're going to strengthen it, or who had tabled amendments to strengthen it. Now we can say, okay, you want our votes? Will you, if elected, pass the amendments that you wanted passed last year and which the government voted down? See, when you're pitching amendments in a standing committee, you may be a majority government, you may be working with opposition, you may have no hope that they're going to pass, but you could be laying the foundation for a later ask of another party when they form the government. I've been around that block a few times, and so the process of getting an opposition party to support an amendment, and when they're in opposition, is the process of getting them persuaded to your policy position well before they may be in position to actually act on it fully and unilaterally. So we mapped out on the 18th of July, it's up on our website, a letter to all the leaders of all the parties saying, hey, if you're elected, what will you do to implement this act? And we listed out a number of things we wanted, 11 of them. And in a number of cases, we said, hey, would you either amend the act or, as a matter of policy, do X? Because we knew the liberals would be more reluctant to amend it. They just passed it. But the opposition might be more willing to amend it. So we wanted to put the question in either way. So what happened? Well, 4 years ago, in the 2015 election, there were promises to pass an accessibility law by the Liberals, the NDP, and the Greens. Tories didn't, even though they had actually promised that in 2006, and when government didn't actually do it, and the Bloc didn't answer. In this election, it was really different. We got a letter from the NDP in which they made a substantial number of the commitments we were seeking, paralleling amendments that they had introduced when they were in opposition at the Standing Committee. We got, just days before the election, a letter from the Liberals, but it promised no changes to the bill, generally said that they would be narrow in granting exemptions, that they would be ambitious in implementing the act, and the only thing they actually committed to that was new, not as an amendment to the bill, but as a policy, is they said, we will apply a disability lens to all government decisions. Disability lens is kind of a term of art in the advocacy world. The idea is they look at decisions before they make them and say, what impact will this have on people with disabilities? Is it going to hurt them? Is it going to take into account their needs? Government does that from a gender perspective. They can do it on a disability perspective. Now, it was interesting that Minister Qualtrough said this days before the election, because when the bill was before the House of Commons, months before, the opposition, I believe it was the NDP, tabled an amendment that would entrench a disability lens, and the government voted it down. But now they're prepared to do it, at least as a matter of policy. No promises they'd amend the law. The Tories, who during third reading debate in the House of Commons in November last year had said, if elected, we will strengthen this bill as a priority, made no commitments to us during the election. Neither did the Greens, who had been strong proponents of improving this bill when it was being debated. During the campaign, we were busy tweeting candidates and asking for commitments and so on. So that's the second last twist and turn, which led to what you all know happened, which is a minority House of Commons. Some people find that frustrating. Our last twist and turn is due to the fact that we find it fabulous, because a minority House opens up a new opportunity. It opens up an opportunity for us to try a new strategy. And we launched that new strategy about 8 hours ago today. Let me conclude this lecture, well, get near the end of this lecture, by telling you a bit about it. What we have done is we have now officially, as of today, the day I'm giving this lecture, we have written the leaders of all the parties in the House of Commons and said, congratulations on your election. You say you folks are going to work together in this minority house. Here's a good example of how you could do it. How about a short, focused bill to strengthen the new Accessible Canada Act? And we've very much along the lines of that 3.5 pager I told you about, crafted over a very stressful and caffeine overladen weekend in April, we have produced a short list of 8 amendments we want. We want the government required to create accessibility standards, actual accessibility enforceable standards in all the areas the bill can cover within 5 years. They certainly should be able to do that. We want the government to entrench the disability lens that the Liberal Party said that they would apply in any event. That would enable them to both live up to what they said they would do, and ensure other governments would do so should they be defeated and another party take power. We want the government to remove the discriminatory remnant of Section 172, so that if a person with a disability faces an undue barrier in transportation that the federal government can regulate, interprovincial bus travel or rail travel or any air travel, that if they face that barrier, they can always get compensation, whether or not there's a weak and inadequate federal regulation on point. We want the government to amend, or we want the House of Commons to amend the bill as well. We'd love to unsplinter this legislation to consolidate all enforcement with the new Accessibility Commissioner, but in a short bill in a minority house, we figured that's more than we can reasonably expect that we could win on. So we've asked for them to require those multiple agencies where there's no wrong door to get in to have the same procedures once you get in. We've said that we'd love to see removed from the Act any power to exempt any organization from parts of the Act, but all we're asking for is that they remove from the legislation the power of the government to exempt itself. We've asked the government to amend the bill to require that when federal money is spent on infrastructure, procurement, federal loans and grants, business development grants, and so on, that that money cannot be used to create or perpetuate disability barriers. By the way, on that point, the Senate didn't make an amendment that we'd asked for, but the Senate Standing Committee did something that they could do that helps us. When they pass a bill, they can attach to it what's called an observation. It's like a comment. So it's a strong message to the government. We're not amending the bill, but hey, fix this. And one of the 2 observations they passed on the Bill C-81 said that the government should establish a process to prevent public money from being used to create barriers or perpetuate barriers against people with disabilities. So those are just some of the key amendments we're seeking. And it's our intention to advocate to all the parties to try to come together and see if they can pass all the 8 amendments we're seeking, or at least as many of them as possible. Well, why has this been such an uphill battle? You're listening to me talking, and you got to think to yourself that this should be uncontroversial. I mean, they all agreed we needed legislation. The parties all agreed that people with disabilities face too many barriers. Any number of them from any of the parties made speeches about the barriers they personally have faced or their family members have faced, and so on. Well, let me offer you just some ideas. And this is kind of an impression from what I've observed, drawing on my years of doing this kind of advocacy at the provincial level before going federal. The first is we got almost no media coverage on this issue. If you are a CBC watcher, you would not know in 2015 that the parties were asked to make commitments, or that any did. You would not know that a minister was appointed to develop a bill, or that a consultation went on nationally. You would not know that the government made a controversial decision before it began, that the CRTC and CTA were going to maintain their hegemony in the area of accessibility despite their poor track records. You would not know that disability organizations called for significant amendments to the bill. You would not know that the House of Commons made some of those amendments but rejected others. You would not know that our community had different views on whether to go to the Senate, but nevertheless went to the Senate. And you would not know that the Senate made real amendments that the government was not particularly thrilled about and didn't want, at least for some of them. You wouldn't know that the bill came back to the House of Commons, and against all odds, the bill was passed with all of the Senate's amendments. And you wouldn't know that during this federal election, we couldn't get commitments from parties that had been supporting us in opposition, or the commitment we got from the federal liberals was so weak. It is especially powerful that the commitments we got were so few in this election, because remember I said this law gives the power a lot of duties, or probably a lot of powers, but not a lot of duties, and we're worried that they don't have obligations and deadlines. It's kind of like a prof saying it's not on the exam. You'll think maybe that's interesting, but I'll worry about it later. Well, the first chance to put political leaders of all stripes to that very test, speaking of exams, was 2 or 3 months after the bill passed, because that's when we went to them and said, hey, if you're elected, what will you do to implement this law? Not only to amend it, but just to implement it. And politicians are typically most responsive to individuals, to voters, when they want our votes. And look how unresponsive they were. Not all of them, but even more of them than were responsive 4 years ago, even more than in response to the bill last fall when it was being debated in the House. It really shows why we need the amendments we're seeking. But politicians also respond to media coverage. Politicians respond to what's in the media. And to that end, if you look at the calendar, when we were raising these issues, we, not just the AODA Alliance, but any number of us before the Senate, what were the headlines full of? The SNC Lavalin case. That was all over the news. That was the subject. Now, that was not the subject 4 years ago, 3 years ago, 2 years ago, and 1 year ago, but at least in the last round, it kind of precluded issues like this. But that's no excuse for the media that didn't cover this, because there are lots of other opportunities. Now, some media did, not enough and not often enough, but that, I believe, was a substantial disservice to us despite our efforts. We and others turned to social media as an alternative, and it's a very helpful means. In 2015, it was decisive in mounting support during the federal election, but nevertheless. Another factor that militated against us, I regret, is the overwhelming weight of the public service. Now, I worked in the Ontario Public Service for 33 years. Public servants that I ever met and have ever dealt with are overwhelmingly decent people. But when they get together in a large organization and an issue like this comes along, unfortunately too often, they can become an institutional drag on progress. I'm confident beyond words, I don't need anybody to call and tell me it happened, that the CTA and the CRTC were busy pressuring the government not to take away any of their mandate. And if anything, they used it to get more mandate. I am confident that the airlines and others that are regulated by those agencies were similarly happy to have those agencies regulating them, and not some new accessibility commissioner that they don't know anything about and don't have a relationship with. And ultimately, while I'm assuming that they did that kind of lobbying, it's certainly, the results are utterly consistent with that kind of lobbying, and no reason to think they didn't. But the other challenges we faced include the fact that advocating on the national level within the disability community, it's a big enough challenge at the Ontario level, believe me, but nationally it becomes an even bigger challenge. both to physically reach people and to try to engage people. This is made even more complicated where people don't really understand what you're taught in first year constitutional law about the lines between the federal government and the provincial government. What's the federal government do? They may be worried about barriers in their local school. And if they go to a consultation session to talk about that and find out that, oh, well, that's really good, but that's provincial, they may find that really frustrating. And the added layer that made this all more complicated or challenging was the fact that with federal funding, there was a presence in this debate within the disability community of a voice sincerely held that was pressing the Senate at certain stages not to make amendments. And that added a challenge in our path. Now, as I said before, it's a democracy. People are entitled to express whatever views they want. And ultimately, we were successful in getting amendments. One is left to simply wish that we didn't have to face that challenge amidst all the other ones that we faced. Let me conclude by telling you that anybody from the outside hearing about any of these stories should think that anybody doing the kind of advocacy that I and my colleagues do must get depressed all the time because the battle is uphill. But I never do. I never do. The fact is uphill is where we live. My earliest experience with this, or among my earliest experiences with this, was back in 1980 when a bar admission student in Ontario, and through a chain of events I cover in another videoed lecture, there was the opportunity to try, I and others, to advocate to get our Charter of Rights amended before it was even passed to include equality for people with disabilities. That was not only uphill, it looked utterly impossible. But through the efforts of many and good fortune, it worked. And throughout the 10 years of fighting for getting the AODA passed from 1994 to 2005 in Ontario, it often looked as uphill. In this case, if somebody were to say to me objectively, do you think it's an uphill battle to try to get a bill passed 4 or 5 months, bill introduced 4 or 5 months after the Accessible Canada Act was passed to make any improvements? Yeah, it's uphill. What else is new? I conclude by telling you about a fortune cookie. A fortune cookie? Back in May of 2005, this fortune cookie said it all, and it wasn't speaking to me. It was speaking to, I believe, disability advocates and organizations everywhere. Back in 2005, the Accessibility for Ontarians with Disabilities Act had been fully debated by the Ontario legislature, and it was slated for third reading vote. The debate was over. It was just the day for a vote. And all parties were on the record that it was going to pass, and it was going to pass unanimously. This was going to be a very exciting day for any of us who were involved in that decade-long campaign. I went to lunch with a buddy of mine beforehand to a Chinese restaurant, and at the end of the meal, they gave me a fortune cookie. Big deal. I went and opened it. Now, of course, there's no braille on the fortune cookie because it would have to be a fortune cake, which I wouldn't mind. But in any event, I passed the fortune over to my friend to read to me, and I kid you not, it was a visionary fortune from that fortune cookie because it speaks to all those who've been involved in the advocacy back then and in the story I told you about today. The line it said is that every great accomplishment is, at first, impossible. Thank you very much.